All rise. Court is now in session. The Honorable Janelle Bolt presiding.
You may be seated. This is the case of Bank of North America versus Kevin Faraday. Case number 2021 CP 226259. Attorneys, please introduce yourself.
Your Honor, my name is James Newman. I represent Bank of North America. I have Ms. Vicki Johnson, who is employed with Bank of North America.
I'm Elaine Gibbs, representing the defendant Kevin Faraday, Your Honor.
Is Mr. Faraday present in the courtroom?
No, ma'am, he will not be present today. I am here on his behalf to defend the case.
Okay, if there's nothing else before we get started, Mr. Newman, call your first witness.
Thank you, Your Honor. If it pleases the court, the plaintiff would like to call Ms. Vicki Johnson to the stand.
Please state your name.
Vicki Johnson.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may be seated. Mr. Newman, please proceed.
Ms. Johnson, where are you employed?
Bank of North America.
What is your current position?
Operations consultant, assistant vice president, and custodian of records.
How long have you been employed with Bank of North America?
11 years.
What are your duties in your current position?
My main duties are to assist our legal counsel in recovering credit card debt by researching credit card accounts.
As part of your current duty, are you required to familiarize yourself with certain records and certain accounts?
Yes.
Are you familiar with the records of Kevin Faraday?
Yes, I am.
May I approach the witness, Your Honor?
Yes, you may.
I'd like to show you what's been marked as Plaintiff's Exhibit 1 for identification. Do you recognize this document?
Yes. Exhibit 1 is a copy of the application of the credit card application that was submitted to Bank of North America by Kevin Faraday.
Do you have personal knowledge of this document?
Yes.
Was it prepared at or near the time of the event?
Yes.
Was it prepared in the regular course of business with the Bank of North America?
It was.
Normally, how is this document stored?
It is stored electronically by Bank of North America's proprietary database that is password controlled, only accessible to those who need to know.
Your Honor, we move that Plaintiff's Exhibit 1 be entered into evidence.
Any objection, Ms. Gibbs?
Yes, Your Honor. We object to this document as hearsay. This witness has not laid a proper foundation for it to meet any exception to the rule against hearsay.
Mr. Newman, how do you respond?
Your Honor, we submit that this document is admissible under business records exception to the rule against hearsay.
You still have to lay a foundation, Your Honor, to render it admissible as a business record. For example, she says that it was prepared at the time of the event. Well, what event? Prepared by who? How does this witness know that? She said she had knowledge, but it has to be personal knowledge in order to qualify. Saying that it was prepared in the regular course of business and just sort of using those magic words is not sufficient. You have to state the underlying. Facts, because otherwise it's just a conclusion, and it's for the court to determine if this is a business record based on the facts that are stated by the witness. It's not for the witness to say the conclusion that it's a business record. So I don't think it's under the business record exception to the hearsay rule.
Mr. Newman, go ahead and lay some foundation.
Yes, Your Honor. Ms. Johnson, are you familiar with how the accounts are stored?
Yes.
Would you describe what you mean by password control? Who has the password? Who has access? How do you qualify that gaining that kind of access?
Well, employees like myself, whose job it is to review the company's credit card account records. We are provided authentication codes, and that allows us to log into the system and access documents such as this.
What type of application is this?
This is an electronic application.
Are you familiar with the process of this type of application?
Yes.
Would you explain this process to the court?
Well, the consumer applies online and provides personal information for applying for the credit card. Name, address, social security number, employer salary, things like that. Bank of North America takes it under advisement, checks for credit worthiness with credit reporting agencies. Then if the applicant is deemed credit worthy, we will open a credit card account in their name and establish a credit limit for the account.
There are information redactions made. Can you explain why those are there, what that is?
It is redacted for privacy reasons, I believe.
Your Honor, plaintiff again asks that a document marked for identification be entered as Plaintiff's Exhibit 1.
Ms. Gibbs?
Your Honor, I still have the same objection on the same basis that I stated before.
Well, I'm going to overrule your objection and find that this has been demonstrated to be a business record and covered by the exception to the hearsay rule. Mr. Newman, you may proceed.
Ms. Johnson, referring now to Plaintiff's Exhibit 1, what name is on the application
Kevin Faraday,
and his address?
5932 Oakway Street, Sumter, South Carolina.
Is the account number referenced on that application? If so, please give the last 4 digits of the account number.
Well, I can't read it real well, but it looks like 8932.
You know, objection, Your Honor, and I move to strike that answer if she's can't really see it or is guessing because it's fuzzy or something. That's just a speculation.
Mr. Newman?
Ms. Johnson,
I'm looking closer and see that it is indeed 8932.
Ms. Gibbs?
I withdraw the objection.
Mr. Newman, you may continue.
thank you, Your Honor. As a result of the application, what, if anything, happened?
Bank of North America opened a credit card in his name, Kevin Faraday.
When they sent Mr. Faraday the credit card, did they include anything else?
Yes, we typically include the terms and conditions for the account.
And that would be physically mailed to the consumer?
Yes.
Okay. Now, I'm referring to Plaintiff's Exhibit 2 for identification. Ms. Johnson, please describe this document.
Well, this is a credit card agreement sent to Mr. Faraday that contains the terms and conditions of the account.
Is it a true and accurate copy of what it purports to be?
Yes.
Do you have knowledge of this document?
Yes.
Was it prepared at or near the time of the event? That is, when the card was issued?
Yes.
Was it prepared in the regular course of the business of Bank of America, of North America?
Yes.
And was it kept in the regular course of business?
Yes.
How is it stored?
It is electronically stored in a proprietary database that is password controlled.
Your Honor, we ask that this credit card agreement marked as Plaintiff's Exhibit 2 be entered into evidence.
Any objections?
Yes, Your Honor, this witness has not properly authenticated this document. And also, I have the same objection to this document. As being hearsay. There's been no foundation laid, or an insufficient one at best, to this witness' personal knowledge of the document, its creation, whether it was mailed to Mr. Faraday and so forth. Saying it was prepared in the regular course of business, again, is merely a conclusion. It's one for the court to make. The witness has to provide the underlying facts that lead the court to conclude that this is indeed a record that was created in the normal course of the business of Bank of North America, whatever that normal course of business is stated to be, and thus, an exception to the hearsay rule.
I'm going to overrule your objection. I find that the document has been properly authenticated by the witness and has demonstrated it to be a business record of the plaintiff, of which she has personal knowledge. Mr. Newman, you may continue.
All right, Ms. Johnson, referring to Plaintiff's Exhibit 2, what is the name on that document?
Kevin Faraday.
And would you please read the top of page 5 regarding the type of contract of the Bank of North America?
Where it says your contract. With us?
Yes.
This document and any future changes to it is your contract with us. We will refer to this document as your agreement or credit card agreement. These terms also include any changes we may make to this document from time to time.
Would you look at page 9 and read the paragraph that's entitled Promise to Pay?
You promise to pay us the amounts for the goods and services you obtain, which includes purchases, balance transfers, and cash advances. You also promise to pay the amounts of all interest charges, fees, and other items charged to your account. You promise to pay any balance within 30 days.
Would you look on page 10 and read the section under default?
You will be in default of this agreement if you fail to make any payment when due. You are in default if you fail to make a payment within 90 days of when it is due.
Now, Ms. Johnson, I'd like to show you what's been marked as for identification as Plaintiff's Exhibit 3. Can you describe these documents?
Yes, these are copies of monthly billing statements in the name of Kevin Faraday, showing all purchase payments, balance transfers, and fees.
Are these copies true and accurate?
Yes.
Do you have knowledge regarding these documents?
Yes.
How are these documents stored?
They are stored in a proprietary data system that is password protected.
Were the documents prepared at or near the time of the event?
Yes.
And are they prepared in the regular course of business?
Yes.
Are they stored and kept in the regular? Course of business.
Yes.
Are you familiar with how the statements are generated?
Yes.
Would you explain that to the court?
Well, if a customer makes a purchase either online, over the telephone, or at retail location, the purchases are electronically transferred. It goes through Visa. It also goes through authorization. If the transaction is approved, it is posted to the account and stored until a monthly statement is produced electronically.
Are they produced monthly?
Yes.
Are they mailed out monthly to the consumer?
Yes, they are.
Your Honor, we ask that these credit card statements marked as Plaintiff's Exhibit 3 be entered into evidence.
Any objection?
Yes, Your Honor, on the same basis as the other exhibits that were offered, Your Honor, the defendant objects to these documents as not properly authenticated and hearsay. Again, the witness has not laid a sufficiently proper foundation for them to show that she knows that they were mailed to the defendant. How she knows with her own personal knowledge that these are true and accurate copies, and whether or not they were mailed to the address that is on them. She certainly didn't mail the originals herself, and so, how would she know that? I think it's clearly hearsay, and she has couldn't possibly have personal knowledge of whether or not these were sent.
Mr. Newman, how do you respond?
Your Honor, we submit that these documents are admissible under the business records exception to the rule against hearsay.
But Your Honor, you still have to lay a foundation to render it admissible as a business record. Saying it was prepared in the regular course of business as a conclusive statement is just not sufficient, and that's for the court to decide. This witness is not able to conclude that this is a business record. She can give the court the underlying facts to demonstrate that it's a business record, but it's for this court to decide whether it is. She needs to have a document that is properly authenticated by someone who has personal knowledge. She was asked if she had knowledge. She didn't say she had personal knowledge, and I think that has to be demonstrated to meet the exception to the hearsay rule under the business records exception. I think she's got to demonstrate, again, those underlying facts to show that there is a business record exception here. She's got to have personal knowledge. That's the only way that it can really be authenticated and a proper foundation laid for her to testify about what's in the document.
I'm going to overrule your objection. I find these documents have been properly authenticated by this witness and has demonstrated to be business record of the plaintiff of which this witness has personal knowledge. Mr. Newman, please continue.
Okay, Ms. Johnson, referring to Plaintiff's Exhibit 3, what is the name and address on the statements?
Kevin Faraday,
And what is the address on the statements?
5932 Oakway Street, Sumter, South Carolina.
How are these provided to the consumer?
They are mailed to the address of record monthly,
What's the last 4 digits on the account?
8932.
And when was that account opened?
March 18th, 2017.
Were purchases and payments made on the account?
Yes.
What was the first transaction?
A balance transfer.
Is that reflected on the application?
Yes, it is referenced on the application. That at the time of the application, the consumer was interested in doing that balance transfer.
When was the last payment made on that account?
Last payment was September 12th of 2019.
And when was the account charged off?
April 30th of 2020.
At the time of the charge off, what was the amount owed?
$5,176.31.
Are there any other credits or payments made on the account after the charge off?
No.
Were any interest or fees accrued after? Terms of the contract and the conditions.
Objection, Your Honor. That question calls for a legal conclusion as to whether or not this is a binding contract. That's for the court to decide, not this witness. That'd be a statement of a legal conclusion.
Withdraw the question, Your Honor. And there was use of the card
Yes.
over a long period, according to Exhibit 3.
Yes.
Payments were made on the charges shown on the statements.
Yes.
That's all the questions I have for this witness, Your Honor.
Ms. Gibbs, anything on the cross-examination?
Yes, Your Honor. Ms. Johnson, how did you verify that it was Kevin Faraday who opened this account?
Well, an application was submitted for approval. Based on all the information, there was nothing in the credit file that suggested that Kevin Faraday did not live at the address that was stated in the application. A CC was submitted, charges made, payments were received. At that point, the bank had no reason to believe that it was not Kevin Faraday who opened the account.
But you didn't really verify that it was actually him in any other way.
I don't know what you mean. Specifically tell me how we would verify that. How would you want me to verify it? Ask for his driver's license?
Well, that would be one way. Also getting his signature, speaking to him on the phone, making a call to confirm that indeed this was a person who was applying for an account with Bank of North of America.
Well, that's not the process of any bank to do that, especially when you open a credit card online.
Well, perhaps it should be. When consumers call in, do they go through any kind of an identification process? You know, if they call in to say something was wrong on their statement, or to say, hey, I don't have this credit card that you're charging me for. You know, how do you
Yes.
identify that it's really the person?
Yes, we get the social security number, date of birth, address, etc., info on the account.
And so when they call, is there a recording of that?
Yes, we have a recording on calls.
Okay, can you explain how that's done?
Well, essentially it's done electronically. The customer calls in, and through a system we do a basic validation. Then the call is transferred, and it is automatically recorded at that point.
Okay, and when a call is recorded, is it stored somewhere in the records?
Well, we now store calls all digitally, so we can retrieve them at a later date if we need to.
Okay. Do your records show any validated calls from Kevin Faraday?
I don't have that information.
Okay, does it show any calls from Kevin Faraday?
I don't know. I didn't review that.
Okay, so that's not part of the records that you reviewed on this account before you came here to testify today?
I don't have that information.
That's all I have, Your Honor.
Mr. Newman?
Nothing further, Your Honor. That's our case.
Ms. Johnson? You can return to your seat. Ms. Gibbs, any motion?
Yes, Your Honor, the defendant moves for an involuntary non-suit. The basis of that is just that the plaintiff has not proven a contract, the breach of the contract, and damages with really any admissible evidence for the reasons stated in my objections earlier. This witness, again, just used that magic word of these are business records, but without really saying how they qualify as business records. And so they just weren't proven to be an exception to the rule against hearsay. She gave no facts that are based on her own personal knowledge to support a conclusion of an exception as a business record to the rule against hearsay. So it's our position that the evidence that was presented is really not admissible pursuant to the objections that we made, not the basis for granting judgment on the plaintiff's behalf, and so we do move for an involuntary non-suit on that basis.
Mr. Newman?
Your Honor, we submit that we have proven that the contract exists between parties. There was a breach of that contract, and the amount that was owed as a result of the damages. We have established that there was an application, terms and conditions of the agreement, that the defendant used the card. Therefore, he was bound by the terms and conditions. He also made payments, and then the contract was breached when he failed to make any further payments as agreed. We have proven the damages in the amount of $5,176.31.
I want to thank you both, attorneys. Ms. Gibbs, I'm going to deny your motion. Based on the testimony and other evidence presented, I find in favor of the plaintiff for breach of contract in the amount of $5,176. and 31 cents. Mr. Newman, prepare the order.
Thank you, Your Honor.
Thank you, Your Honor.